Hey everyone, the right of quiet enjoyment is a fundamental legal protection for tenants, ensuring that they live in and use their rented property without undue interference from the landlord or anyone else. Despite how it sounds, this right is not just about noise. It refers to the tenant's right to undisturbed possession, meaning they should not face excessive disruption such as unannounced visits by the landlord, unwarranted entry, harassment, or actions that make living in a property unbearable. This right exists even if it's not explicitly stated in the tenancy agreement, as it is implied under common law and in some cases reinforced by statutory provisions. However, the right of quiet enjoyment is not absolute and can cease in certain situations. If a tenant violates the lease agreement, such as by failing to pay rent or engaging in illegal activities, the landlord may have grounds to terminate the lease. The right also does not apply in emergencies, where a landlord has the legal right to enter the premises to prevent damage or protect the property, such as in cases of fire or flooding. Some tenancy agreements also include clauses allowing landlords to enter for periodic inspections, repairs, or viewings for potential buyers or new tenants. Additionally, if a court orders the tenant's eviction, the right of quiet enjoyment naturally ends. A common breach of this right occurs when landlords repeatedly enter a rental unit without permission. For instance, a tenant may find that the landlord frequently uses a spare key to enter the property unannounced, checking on the place without their consent. This makes the tenant feel uncomfortable and disrupts their privacy. Unless it is an emergency or specifically allowed under the lease, this would be a violation of the tenant's right to quiet enjoyment. The tenant could demand that the landlord stop entering without permission, and if the problem persists, may have grounds for legal action for breach of contract or harassment. Another scenario involves the landlord cutting off utilities to force a tenant to vacate. Suppose a tenant refuses to leave a rental unit before their lease expires, and the landlord retaliates by disconnecting the electricity and water. This tactic, often used to pressure tenants into moving out, is not only a breach of quiet enjoyment, but could also amount to an unlawful eviction. The tenant could take legal action, as landlords cannot interfere with essential services in an attempt to force a tenant out. Renovations and excessive noise can also interfere with quiet enjoyment. A tenant who works from home may find it impossible to concentrate due to ongoing drilling and hammering from extensive renovations initiated by the landlord who lives in the next room or next door. While landlords have the right to renovate their property, excessive disruptions that make the unit unlivable could be considered a breach. In such cases, the tenant may negotiate for a rent reduction during the renovation period, or in extreme cases, seek to terminate the lease. The right of quiet enjoyment is an essential protection for tenants, but it must also be balanced with the rights of the landlords. While tenants have the right to live undisturbed, landlords also have the right to maintain their property and ensure lease compliance. Unlawful evictions, harassment, and unauthorized entries can have serious legal consequences for landlords. At the same time, tenants should understand that reasonable entry for necessary repairs or property viewings is permitted if stipulated in the tenancy agreement. When disputes arise, an amicable solution is always the best approach. If that fails, legal recourse may be necessary. Thanks for joining me in this video on the right of quiet enjoyment. Don't forget to like, share, subscribe. I'll see you in the next one.